Let's talk South Carolina gun laws. So we're going to go through some of the key state laws. We're going to go over the overview. We'll read a little bit of case study when it comes to actual self-defense and how it plays out in the courts up there. And then you guys let me know too if you want a specific video diving deeper into the case law, because I won't get into it that deep in this video, but it does kind of deserve its own video, but we'll talk about it here. Getting into it. South Carolina, you shall issue your permitless carry. As of March 7th, 2024, open carry as well as concealed carry is legal without a permit to anyone 18 years of age or older who is not prohibited by law. So you guys are one of the few states that do allow 18-year-olds to legally carry a firearm, although you still must be 21 in order to purchase a handgun. That is a federal law that applies to all states. But for long guns and rifles in South Carolina, I assume those will be okay for you guys. CWPs are issued to residents and non-residents who own property in the state or a military personnel stationed in South Carolina. Concealed carry permits require an 8-hour firearms training course, and they have to be approved by the state. You can be 18 years old and get a permit. So again, you guys are one of the very few states that allow a person to be 18 and get a concealed carry permit. Although, like I said, you are still not able to federally buy a handgun. That is a federal law. All states have to abide by it. In terms of reciprocity, South Carolina honors residence permits from states that recognize South Carolina permits, provided that the reciprocal state requires an applicant to pass a criminal background check and go through a firearms training process. So, for example, New Hampshire, your permit will not be honored in South Carolina because you guys do not require a person at least go through a firearms training portion. I think you can apply for a New Hampshire carry permit online and they'll mail it to you. So New Hampshire, you do not work inside of South Carolina. Let's go to the key state laws. We'll bounce around a little bit. Actually, let's just go into some of the carry basics, just kind of keep it all in the list. Are there ammo restrictions? Yes, the possession and sale of Teflon-coated ammunition is prohibited. Open carry is legal, as we've already stated. There's no magazine limits. Other weapons allowed to be carried besides a handgun. No concealed weapon means a firearm that has a length less than 12 inches. So you cannot you can't conceal carry an AR-15, anything like that. In Florida, we have a weapons permit. We don't have any prohibition against that. We do have other weapons that we're allowed to carry besides just a firearm, which would be, a firearm is a firearm either way, but we have a weapons tag on our firearms license. We have a concealed weapons and firearms license. So that's Florida. So you guys don't have that. You cannot carry anything that has a barrel longer than 12 inches. Constitutional carry is a yes. Non-lethal weapons that you can carry. Stun guns, yes. Pepper spray, yes. Tear gas, legal for self-defense but subject to general misuse laws. Bear spray, you can use it against wildlife. There's no specific state restriction, but misuse laws against humans do apply and legal consequences can come about. Batons, yes. Brass knuckles, legal under South Carolina law. There are no explicit bans on the possession, sale, or use, which is different than Florida. Again, in Florida, you must have a concealed carry license if you're using brass knuckles, and misuse laws still apply. Byron guns, yes, those are legal for purchase and possession. You don't need a firearms license because they're not classified as a firearm. If you don't know what a Byron gun is, those are the new little guns that kind of shoot pepper balls. So essentially it's a pepper spray gun, but no spray, pepper balls instead. Let's go into some of the key state laws. You are in no duty to inform state, so you do not have to let officers know that you have a firearm. You have no duty to inform. Brandishing, most states do not have a definition of brandishing, but however, it is unlawful for a person to present or point another firearm at a person loaded or unloaded. That can get you some time in jail. Public accessory to concealed carry registry. South Carolina makes the information available to law enforcement. In addition, the South Carolina Law Enforcement Division must publish a report annually during the first quarter, which includes detailed information regarding individuals who have had their permits revoked and the reason for so it doesn't quite give a specific answer. It looks like it's private, but once a quarter it's published. So I don't think it's South Carolina, it looks like that's kind of a gray area where there's a public access to the concealed carry registry. It does say that they publish a report annually for the first quarter, but we don't know who all has access to that. It doesn't specify it in what I'm reading. No weapon allowed signs. Yes, all signs must be posted at each entrance of the building where it's considered. So no weapon allowed signs are enforced inside of South Carolina. Non-resident permitting, yes, if you own property in South Carolina. If you don't own property, you can't get a permit. But if your state has a firearms training portion and a criminal background check is a part of your permit process, then you can carry with your out-of-state license. Your driver's license is not linked to your CCW, so that when they run your driver's license, they will not know. There are no red flag laws, and the state does have preemption over laws in South Carolina, except municipalities may regulate the careless or negligent discharge of a firearm, may temporarily restrict other lawful open carry or firearms on public property. So for the most part, the state has preemption, but local ordinances can enact some laws when it comes to the lawful discharge or where you're allowed to open carry. So small things of that nature. Waiting period, there's no waiting period required when you're purchasing a handgun. Possession of a handgun on private property, of course, that's most states. You don't need a permit for that. Background checks for private sales, there's no background check on private sales. Permit to purchase, you don't need. Minimum age to possess and transport is 18. Handgun registry is a no. And then this last one, maybe it's kind of iffy. Some people, like when I did it for Georgia, they told me it wasn't true, but then the information I'm reading, which is pretty credible, is saying that it is true. So if you have a permit inside of South Carolina, you're exempt from a background check. Again, you guys can let me know in the comment section if that is true. And then let's talk about a carry location. Can you carry inside a vehicle? Yes, as of March 7th, 2024, permitless transportation of carrying a firearm in a vehicle on or about the person, whether openly or concealed, loaded or unloaded in a manner not prohibited by law, is allowed. I do like the way that you guys wrote that there. A firearm in a vehicle on or about the person, whether openly or concealed, loaded or unloaded in a manner not prohibited by law, is allowed. That gives very specific criteria. In Florida, I argue that we have a little too ambiguous, where for us it just says securely encased or not readily accessible. If I securely encase it in a holster, does that also mean it needs to be concealed? We are a concealed carry state, but in the car, I mean, you're technically in a private dwelling inside of the car. You have a Fourth Amendment right to that. So we don't have enough specificity, but you guys here make it very clear if it's on or about the person, which about the person, they do try to argue a lot in Florida, you're fine. So I like the way that you guys wrote that to just eliminate that gray area. State or national parks, yes, you can't go into the national park like museums if they're on that property. Carry inside of bars or restaurants, yes, unless they have a no guns sign posted. And then carry at hotels, yes, but hotels can refuse because they are private property, so it all depends on them. Let's talk about, so now we'll get into the self-defense portion. So South Carolina, you are a castle doctrine state. When you're not engaged in unlawful activity and you're attacked in a place where you have the right to be, you have no duty to retreat and has the right to stand his or her ground. Now, like I said, we're going to get into some of the case law about this, but let me keep reading some of this criteria right down here. A person is presumed to have reasonable fear of immediate peril of death or great bodily injury to himself, herself, or another person when using deadly force that is intended or likely to cause death or great bodily harm to another person if that person against whom the deadly force was used is in the process of unlawfully or forcefully entering, has unlawfully or forcefully entered a dwelling, residence, occupied vehicle, or if he removes or attempts to remove a person against whom that person is inside their dwelling. So if they're trying to drag you outside of the house, if it is road rage and a carjacking and they're trying to drag you outside of the car, you do have a right to use force or deadly force to protect yourself in that instance. It goes on to say, a person who uses deadly force knows and has a reason to believe that an unlawful or forceful entry or unlawful or forceful act is occurred or has occurred. So that one kind of breaks down to if someone has forcefully entered your house and you are then approaching your house and you see that they have forcefully entered, you are still allowed to use deadly force. At least that is how it is reading. Because again, it starts with saying against whom deadly force is used is in the process of unlawfully or forcefully entering or has unlawfully or forcefully entered a dwelling. And then we connect that last sentence where it says, who uses deadly force knows or has reason to believe that unlawful or forceful entry or unlawful and forceful act has occurred or act is or has occurred. I'm sorry. So if it is or has occurred, which has is that in the past tense, if someone has broken into your home, that is unlawful or forceful entry. So then you are good there. We're going to go on to read this last portion here. A person who is not engaged in any unlawful activity and who is attacked in another place where he or she has a right to be, including a person who is not engaged in unlawful activity and who is attacked in another place where he or she has the right to be, including but not limited to a place of business, has no duty to retreat and has the right to stand his or her ground and meet force with force, including deadly force, if he or she reasonably believes it's necessary to prevent death or great bodily harm or great bodily injury to himself, herself, another, to prevent the commission of a violent crime. So, and then let's define dwelling, because this also matters. Dwelling means any building or conveyance of any kind, including an attached porch, whether the building or conveyance is temporarily or permanently mobile or immobile. If it has a roof over it, it is considered a part of the dwelling. Residence means a dwelling in which a person resides either temporarily or permanently, or visiting as an invited guest. So, we have those definitions now. Let's read a little bit of case law that starts to explain how this really works. So we are going to look at pretty much 4, and we're going to talk a little deeper about 2 that I just read about. We're going to start out with where stand your ground was upheld. So in State versus Jones, 2012, Shannon Jones lived with her boyfriend, Timothy Glover. They got into a violent domestic argument inside their home. Glover became physically aggressive. To give you more backstory, they were arguing. Glover, which is the boyfriend, was throwing things around, kind of really going irate. Shannon, or we'll call her Miss Jones, left, and then she came back. She left to give herself a cool-off period, came back. Glover is still throwing things around, still going irate. Eventually, she grabs a knife. So Jones grabs a knife. She has cousins, I believe, with her. She goes inside, grabs a knife because she's afraid that he may get super irate because he's throwing her things around, throwing her phone around. So she grabs a knife for protection. Eventually, Jones is grabbed by Glover. So Glover grabs her, is starting to shake her. Jones grabbed a knife from the kitchen and stabbed Glover once in the chest, killing him. So that's kind of the short version. He grabs her, starting to shake her. He's saying it's over. This is all your fault. She is fearing that he is going to punch her or hit her at this point. So she stabs him once in the chest. He falls. She leaves. She gets in the car. Her cousin, who I don't know the name of in this moment, they get in the car and they drive off. She then tells him that, hey, I stabbed him. They go back, pick him up, drop him off at the hospital. He dies at the hospital. Initially, they tried to deny her claims for self-defense and convict her on murder. The prosecution argues that stand your ground should not apply because the victim lived in the same residence as Jones and could have retreated to another room. It's interesting that the prosecutor would try to add this retreat clause in because, as we just stated, South Carolina is a no duty to retreat state. This is a very good example of how stand your ground is upheld and how it works in the right way. The ruling, the Court of Appeals ruled Jones was entitled to immunity under Stand Your Ground and the Protection of Person and Property Act. The law does not require retreat if the defendant is attacked in a place they have a right to be, including their own home, even when the aggressor is a co-resident. So in this case, it was kind of ridiculous of the prosecutor to state, hey, you don't have a right to stand your ground of self-defense against somebody who also lives in your house. I don't know how you can pose that argument when I have a right to be in the house, they have a right to be in the house. But just because we both have a right to be in the house doesn't mean that they have a right to put my life in danger. And then to say I should have retreated to another room, that goes completely against what our self-defense laws are, which castle doctrine allows me to protect myself in my own castle. No duty to retreat means I am not obligated by law, and you cannot mandate by a matter of fact in the law that I retreat first before protecting myself. And then, of course, stand your ground. Like, I'm allowed to stand there and face whoever is trying to attack me. So key points in this one is stand your ground extends to domestic situations, not just strangers and confrontations outside of the home. So that is a very good one of inside the house. But what I want to specify in this one is this is a man deliberately attacking a female and a female using self-defense to protect herself. If we go to the complete contradiction of this one, which would be State versus Stute, which is a 2025 case. Isaac Stute was charged with second-degree domestic violence after a confrontation with his girlfriend. The backstory on this is they're in the drive-thru of some restaurant. The girlfriend thinks that there's some other female that is tracking Stute through some means. So they're getting into an altercation or they're getting into an argument. Stute says she is flailing her arms around and starting to hit him and attack him, and that he then grabbed her wrist to try to prevent her from actually attacking him. And in that process, he does state that, it's funny what he states, that the back of his hand just somehow went across her face at a point. He didn't really mean it as intent to do harm, but in the process of just her flailing around and different things, she's hitting him, he backhands her. That's essentially the breakdown of it. And like I said, if you guys want this in a complete individual video, where I'm also going to put some animations, let me know in the comment section, say, we want case law. We'll do that video next. But so in this case, Stute he does attack her, he does slap her. It pushes one of her teeth back and her mouth is cut. Stute claims that she attacked him first and that he only grabbed her arms to restrain. At trial, the judge refused to allow the jury to hear self-defense instructions, saying the evidence wasn't strong enough to support it. Stute was convicted on second-degree domestic violence. So again, instead of a female using self-defense against a male, this is a male using self-defense against a female, and the judge and the state didn't even allow the jury to consider self-defense claims, stating again that Stute had the best ability to leave the situation, which I don't understand how, considering they're inside of a car. Again, you have the right to defend yourself inside of a car. They're stating that because of the size difference, that force is unreasonable to come from Stute. Again, that is kind of an absurd thing to say, that because I'm bigger, a female should just be allowed to attack me, or that I can't attack her back because any type of force that I use would be disproportionate to the amount of force that she could inflict on me. I think that is completely bonkers. Like, that is just not an argument that should stand. Eventually, the Supreme Court did step in and they reversed the conviction, emphasizing that if any evidence, no matter how slight, that supports self-defense requires the jury to be instructed on it. So in this instance, the jury, the fact of if there is any type of self-defense in this case at all should be determined by the jury and should not be determined by the judge solely. And if that there is any evidence of self-defense, it has to be weighed in, and you can't just automatically dismiss it because he is a bigger male and she's a smaller female. Does he have any type of cuts on him? Does anything of that nature exist on him? If so, this should be considered and his claim of self-defense should be taken into account. So those are two, just contradiction. Let's go back to another one where stand your ground was upheld, State versus Douglas. Following an argument inside of a nightclub, a fight spilled out into the parking lot. James Douglas was confronted by another man. Witnesses testified that the victim was advancing on Douglas, threatening him and attempting to start another fight. Douglas drew a firearm and fatally shot the man. Prosecutors argued Douglas could have left the area instead of fighting. Again, it seems like prosecutors always want to go for this, you could have retreated. You have no duty to retreat, and this is why it works so well, because if this was a state like New York, yes, you're going down immediately because you could have gotten out of there. But in a state where you have a no duty to retreat clause, they cannot use the fact that you could have retreated against you, because you have no duty to retreat and you have a right to stand your ground. If you turn your back on him, how do you know that he will not pull a gun on you and shoot you in the back? You have to, you can walk backwards, you can get in the car, but at some point you have to not face them face to face. And at that point in time, how can you determine that your life will that you're not in danger of death or great bodily harm? It's interesting that in a no duty to retreat state that the prosecutors are constantly trying to use a retreat clause in order to penalize people. But again, in this one, the ruling then became the South Carolina Court of Appeals upheld that the trial court's decision to grant immunity under stand your ground. They found Douglas was lawfully present in the parking lot and had a reasonable fear of immediate harm. Key points the state stand your ground applies to public places where the defendant has a right to be. So he had a right to be at the club. He wasn't breaking any laws. The individual approached him. People testified that the individual kept trying to spark another fight with him. We don't know. I didn't read the case law deeper on this one. So again, if you want the case law, comment, we want case law. I don't know how big the other individual was, but Douglas decided to pull his firearm because he felt like his life was in danger enough to pull his firearm and discharge, and stand your ground with no duty to retreat prevailed in the end, and he was allowed immunity in this situation from a murder or homicide in this situation. The last one we'll read is State versus Sober. So Marcus Sober was charged after shooting at another man during an altercation. At trial, the defense requested a jury instruction on stand your ground immunity, asking jurors to decide whether he should be acquitted under the statute. The trial judge denied the request, ruling it was not for the jury to decide, which we then get into a contradiction. So the jury cannot decide whether stand your ground was there. The jury, if we look back to the Stute case, the jury has to decide whether a means of self-defense was necessary, not if a matter of stand your ground should be applied or not. So there's the key difference there if you were confused there. A jury decides based off just these two cases. If we're looking at Stute and we're looking at Sober, which again, eventually Stute was the Supreme Court did reverse the conviction, but initially it was rejected just as it was in Sober. In Stute, the Supreme Court said the jury needs to be able to decide if any means of self-defense or self-defense was applicable in this situation. Was there any evidence that he was defending himself? In this one, the defense requested that the jury instructions on stand your ground immunity be weighed. Looks like those are two different criteria. One is a sub-criteria of the other. So a judge is the one that is going to rule if stand your ground immunity is going to be applied or not the jury. The ruling, the Court of Appeals agreed immunity in a pretrial question for the judge is for the judge, not the jury issue. If the judge denies immunity, the case goes to trial as a normal self-defense case. Key points: Sober clarifies procedures. Stand your ground must be argued before trial in a separate evidentiary hearing. So again, if you're doing stand your ground, you can't ask for the jury to evaluate stand your ground. The jury has to evaluate self-defense. Stand your ground is going to be a clause that is applied and looked at through the judge's eyes, not through the jury's eyes. So those are just a couple of case rulings. This is the newer format, so really, if you guys watch this whole video, please tell me how you like this format. Maybe I can change up where and how I organize the information, but I think adding the case law in there gives a lot of context that really makes it make sense. One of the new positions that I'm taking in this channel is to potentially redo the gun laws of America. Some of them just don't make sense in terms of how some of the prosecutors are even trying to adjudicate these. Doesn't make sense. As we saw, 2 times the prosecutors said you could have retreated even though you're in a no duty to retreat state. This is why law is a practice. Disclaimer, I am not a lawyer. I am literally just verbatim reading what is already on the page and what has been adjudicated by judges and argued by attorneys who practice law and have a law degree. I do not. But if we can read some of these and bring some of these to light, because I don't know how many of you know about these, but if we can bring these to light and give these attentions about the contradictions in the law and how they just aren't very coherent enough, maybe we can actually work to make our legal system a little bit better. So again, let me know how much you guys like this format, if you guys like this format, if there are any other cases that you would guys like me to touch on, or if you would like a more detailed breakdown of each one of these cases. Again, comment "we want case law" down in the comment section, and I will do an animated thing where we kind of give illustrations to make it a little bit more intricate instead of just me talking about the case laws here. I appreciate you guys, South Carolina. I will try to come up there and host a class, but I believe that class is in North Carolina. It's a long distance shooting course hosted by Dope Precisions. There are a couple Marines that are still active duty, that are doing a lot of cool stuff in terms of the sniper and long distance range shooting. So be on the lookouts for that. We are hosting a course down here in Orlando on November 8th and 9th. So if you want to come to Orlando to take the class, you can. And if not, we will just get you booked inside of a class inside of North Carolina in a couple more months when we plan that out. Again, thank you guys for watching. Stay on mission. I'll see you in the next video.